This is a guide for why we verify the law and a reinforcement of, for our purposes, Shepard's, but also a reminder about key cite. Before a lawyer presents any document to the court or anyone else, they must be certain that the information they are relying on is both up to date and relevant. We've discussed this many times in many contexts during Research 1 and Research 2 and about every other course in our paralegal program. Running a Shepard's or key cite report will help you determine whether the cases or statutes to which you are citing are still good law. Shepard's and key cite are examples of online citators, and there are other examples. There are other vendors, but those are the two primary ones, as we've discussed. A citator allows someone conducting legal research to enter the citation to a particular case and discover all documents that cite that case to determine the court's decision is still considered good law, or if it has been reversed, overturned, superseded, vacated, or treated negatively to such a degree that it should no longer be relied upon, or at the very least explained as persuasive only. Shepardize or key cite or use a citator for every case. Citators also allow the researcher to verify that statutes, court rules, constitutional clauses, and other documents are good law. But in practice, the availability of web-based versions of the up-to-date options for these primary sources of law make it unlikely that you'll use a citator for this purpose. For these resources, the citator will be more helpful in your day-to-day practice by leading you to additional resources, cases, articles, etc. that you find in the annotations of those statutes on, say, Lexis or through Shepard's. If you're uncertain as to whether a statute or court rule or whatever administrative rule, primary source of law is up to date, Shepardize. But in most instances, the value of Shepard's on these resources is going to be in leading you to other resources, cases in particular, that cite and help us understand the application of that rule, statute, administrative code section. A Shepard's or key cite case law report will provide two types of case law citations. And you should know the difference. So the first would be history citations. History citations are cases that are directly linked to the case being Shepardized or key cited. It's either a prior part of that case at a lower level court, or it's a subsequent decision that could be, remember, reversed cases go back, so it could be from that same prior court, or it could be up the chain. And so remember that. And that is, it's the same case. It's a history of the same case. If there's a subsequent or related case, you'll want to follow that trial or that appeal and determine where the case went next. In particular, what did that other court say about the issues that are most relevant to your use for that case? Now that's different than treatment citations. And treatment citations is probably where you're going to spend more of your time. Treatment citations are cases that have cited the case being Shepardized or key cited, but they are not directly connected to that case. They're not the same parties. They didn't flow from that case that's in our historical citation. These decisions may follow the case you're shepherdizing, may distinguish it, or may disagree with the cited decision, among other things. Most of the time you spend will be chasing treatment citations, finding and reading other cases that lead you to other potentially relevant cases. Remember, you won't know if the case is relevant until you read the case. Don't rely on publishers like Shepard's and West and their summaries of the case. Don't rely on their headnotes. If it looks like it might be relevant, or if it's something that Shepard's leads you to, take the time and read the case. Be sure with the most important computer you have at your disposal, your brain, that you read the case and you make your own determination as to relevance or application. A Shepard's or KeyCite report can also be used for research purposes. The results list from either service will provide you with many other cases and resources. If you're doing a statutory search, KeyCite or Shepard's reports will also identify new or pending legislation. And from time to time, we all know that there is new or pending legislation. We just may not have the text of it as easily accessible. And so this is how we find it. Note, however, that services may not catch cases or legislation indirectly overruling a particular case. Again, read. Read, use your brain, and you will know. Both Lexis and West allow the researcher to use the search within results type feature. This feature allows you to narrow your search to specific issues or factually similar information using terms and connectors just as you use and have become accustomed to use in Lexis. This feature is useful when there are hundreds or even sometimes, as you know, thousands of documents. Now again, since we do a lot of jurisdiction-specific research in the practice of law, Lexis, for instance, looking over to your left, the left of the screen, and then making sure that you've used those pull-down menus to narrow what you're looking for to that resource that you're looking for. 3rd District Illinois Appellate Court cases. As an example, you can narrow that search or make sure that you're in the right jurisdiction, state, federal. Shepard's and KeyCite provide similar services, but there are some features and search capabilities that are unique to each. Now, we provide Shepard's as part of our Lexis service that we provide to all students in our program, but it may be that you go to work for a lawyer who uses Westlaw, or maybe even a resource that isn't Lexis or Westlaw. Regardless, if it's Westlaw, you'll be able to navigate KeyCite. If it's some other system, you will be able to navigate that system. The elements, the process, and the intent are exactly the same for these two or any other citator you may encounter in your career. Remember the purpose. Remember how you do things and why you do things, and follow the processes that you've taken from what we've suggested and adopted on your own to things that make sense for you and your clicks of the keyboard and the mouse as you go through this research process. You're familiar now with symbols, citator symbols. Both Shepard's and Lexis and KeyCite rely on similar, though not identical, sets of symbols to indicate the status of cases. The symbols are called signals in shepherds and flags in key sight. A red symbol indicates the case is either bad law or at least one point of law has a significant amount of negative treatment. In Lexis, a red symbol is not an automatic indication of bad law. It may be bad law, but the case may have some negative treatment. It may be only on a particular issue that it may be bad for your purposes. It may be useful for your purposes. Again, read the case. You won't know until you read the case. If the court has rejected a principle of law that you thought you were going to be able to rely on, or may be favorable to your client because the court rejected it, you won't know this until you read the case. Read the case. For Wes, a red symbol indicates that the case law is bad law on at least one point of law. However, other parts of the decision may still be valid. You want to look at the subsequent case here too. So any citator, you get to the red symbol, don't automatically think it's bad law. The way I suggest you look at these symbols is the same way that I hope you look at these colors while you're traveling down the roadway. Red means stop. Look around. Head on a swivel. All parts of the intersection. And assess before you proceed. Okay? You assess by reading. Don't use what they tell you as that red signal as being stop, and you don't have to proceed through anything else. You do. You have to proceed through the intersection to read the case. Yellow is used a little more liberally. A single negative action in a completely unrelated jurisdiction can cause a yellow symbol to appear. Actions that may trigger yellow, but are not limited to these, are distinguished, criticized, explained, or questions from the appellate court. You will want to look at the cases that cause the yellow symbol to appear, but do not be surprised if the negative action is very minor or remote to your case. In other words, when you approach a yield sign, a yellow sign, you are obligated to proceed with caution, to slow, to stop if necessary, to yield to oncoming traffic or traffic that has the right of way to turn in front of you. Slow down if you see yellow. But the expectation is the same. Read. Now, if they give you the green, you may be inclined to throw your vehicle into fifth gear and fly. That would be a mistake. If that's the case, you need to proceed with caution. Don't throw it into fifth gear. Keep it in third gear. But read the case. And as you're reading the case, and when you find out it does apply, knock yourself out. Throw that clutch to the floor and that shifter into fifth gear and fly. But you know where you're flying to? Right back to Shepard's. Now Shepardize that case. And you better downshift or you're going to go off the road. Fast and research never gets you where you want to go. It just doesn't. Enjoy the ride. Take it slow. Keep your eyes open on the road and do all the things you need to do. Going fast is not advisable. So even on the green, Don't go above third gear. There's a chart of shepherd symbols provided on the final page of the document that I included with this guide in your course documents. When looking at shepherds or key site, the only relevant symbol is the one before the case name, citation you're shepherdizing or key citing. The symbols before the other cases retrieved in the report are not relevant. Those symbols indicate whether the cases that relied on your decision are still good law. It's important to note that you should not rely on the symbols as the sole source of information. Okay? Read the cases. You must read the cases to make your own determination of the citing case's effects on the decision at hand. We live in this click or ask Siri type environment. The most important part of the legal research process is you, your eyes, your processing, your brain. Use it. So in summarizing, always verify your research. I provide examples from time to time of a circumstance that I had encountered or witnessed where I was involved in the case. The opponent in my case failed to shepherdize, failed to verify law that they presented when it should have been done. The very case that they relied on was reversed by the Illinois Supreme Court. They wasted my time, my client's time, their client's time, the court's time by putting us all through a hearing and then act shocked when both I and the court noted that there was this other case. That lawyer ended up with an ARDC complaint from both me and the court. They ended up, and the court told me I had to do that. At the time I hadn't realized, I guess fully, that I needed to do that, but I did. They ended up facing sanctions. They paid for my fees for the hearing. They had a ding on their reputation and career, all because they did not shepherdize. Now, I linked to the document a video from a pretty famous case. It's a short video. Watch the video. The video depicts an accomplished lawyer who was standing at the podium making an argument using bad law that her team had provided to her. She relied on the research from her team, and her team didn't follow the process. That was televised live on CNN. Most of the time when we get embarrassed in court because someone on our team didn't do what they're supposed to do, worst case scenario, there's a room full of other lawyers or other people. So less broadly broadcast, but still a ding on the reputation. I don't know too many employers who would come back to the office after that experience and be in a good mood. And it's all avoidable. It's because someone did not follow the process. They did not use the process. They did not use the tools of the process. as intended. Citators are a major tool in the research process. Use them. Use them as I suggest. Use them as we teach in every research project, both while you're a student and especially while you're out there practicing as either a paralegal or, for some of you, eventually a lawyer. I hope these resources are helpful. I hope you use this resource. And if you have any questions, you know where to find me. Stay well.